On numerous occasions, to preempt land disputes and potential conflicts, many individuals opt to lodge a caveat on the land. But for those unfamiliar with the process, what is exactly a caveat on the land, and why is it important?
The law provides that any person with any interest in land can lodge a caveat if that land is registered land. In Uganda, registered land is either freehold or milo or even leasehold. So any person who, if you are claiming an interest in land, it means that you can lodge what we call a caveat on the land. And caveat is basically, or simply put, saying that me, so and so, I have a registered interest. And it's usually in circumstances where a person is not the one registered on the land title. For instance, the interests can vary. You can be a chibanja holder on registered land. So the land is in the names of XYZ, but ABC has a chibanja on that land. That means the person claiming a chibanja on the land can lodge a caveat on the land title, saying, I have an interest of a chibanja, and the interest should be spelled out. I have an interest on a chibanja on so and so's land. Some other interests can be where someone sells to you land, but before they transfer, you can't find them, you can't trace them. Then that means that I am the owner, but I'm not yet registered. So I'm putting my interest to the whole world, and the intention of the caveat is to put the whole world on notice. Because when it comes to registered land, it means that there is an office which administers that land, which we call land offices in Uganda, or MZOs. Every time a title is released, it's released in two copies. There's a copy which is retained in the land office, which we call the original, and the owner's copy, which we give to you. Now the caveat is lodged on the original, which it retains in the land office. And why it's a notice to the whole world is because if anyone wants to carry out a search on the land, they go to the land office, and there they will find that so and so has a caveat on this land. He's claiming a chibanja, he's claiming that he bought, he's claiming that he has a lease. The interest should be known, and you should prove it in the document which you take to the registrar to lodge your caveat. So any person who says that I have an interest in land, especially if you're saying that the land is not, right now it's not in my name, but I have an interest in it, you are free to lodge a caveat and inform the whole world, because if you lodge a caveat, it's assumed that you've informed the whole world that you have that interest.
Under what circumstances can one lodge a caveat on the land, and what is the process one must go to acquire a caveat on the land?
Before they lodge a caveat, the registrar will have to ascertain that indeed your interest is a legal one which deserves to be protected. That means that if a person is lodging a caveat, they will do a caveat document, and then you attach, you accompany it with an affidavit. The affidavit should be able to spell out the nature of your interest. For instance, I bought land from Deborah, I've not seen her since then, and I fear that the land may be transferred without my knowledge. So I'm lodging a caveat. Or our father passed away, and we're in the process of getting letters of administration, but we hear land may be transferred again behind our backs, so we are lodging a caveat. So the document will have to be registered in the land office, and it's registered onto that original title which remains in the land office, such that any person who comes to carry out a search will see that there is a caveat on this land, and this is the nature of interests.
To lodge a caveat on the land, one must provide the Registrar of Lands with evidence. Conversely, one seeking to remove a caveat on the land needs to follow the same procedure.
When it comes to time depends on the nature of caveat. There are some caveats which lapse just by the kind of interest they had. For instance, if I'm the owner of a mile piece of land, and I gave out a lease to a person on that land for 5 years, and that person caveated my land for that particular purpose, that means that at the lapse of the 5 years, the caveat will be done, will naturally have lapsed. It will be off, and because it was time set, it was time bound, that it's for 5 years, I have a lease. You even attach the copy of the agreement of that lease. Then there are some others which do not just lapse. For instance, if I'm saying I'm a beneficiary in the estate of my late father, and right now the land is in the names of either my late father or the administrator, and we fear that it may be transferred behind our backs, then that one doesn't lapse. It will be there until it's either vacated by the person who is on the land or who is on the title, or if you withdraw it yourself, or if it's a spouse, what we call spousal caveats, where the wife or the husband says the land is in the names of my wife, but I fear she may transfer it, yet I'm married to her, and that's where we stay. That's also one which will not easily lapse. Or the chibanja holder, a person may be claiming a chibanja holder, although one of the chibanja holder may not necessarily hold transfers, because there are those which are meant to hold transfers, where they're saying that I forbid any registration or transfer into that land unless I'm told. Because ordinarily some chibanja interests will exist even after change of ownership of the land interest. So the when do they lapse depends on the time and the nature of caveat.
Because there is someone who had the land, who had put a caveat on the land, then they told her that, the caveat elapsed, like after 6 months.
It's not accurate that after 6 months they automatically lapse. No, it depends on the type of caveat. If it doesn't have a time element, like for instance, if a person is claiming the chibanja ownership, that I'm caveating this land and because I have a chibanja interest, you can't say that after 6 months the chibanja interest no longer exists. Or even a spouse, or even a beneficiary, or even anyone who is saying I have a lease on that land, which is for 5 years. Because even registrars are supposed to first ensure that you've brought enough evidence to prove your interest. Because not everyone who claims an interest that they will lodge, they should not lodge caveats on people's land unnecessarily. But an affidavit, which is deponed before commission of oath, should show the nature of your interests quite clearly, saying I bought from that man and a copy of the agreement is here. I finished, he even signed for me transfers, but he didn't bring for me the certificate of title. I've been looking for him, blah, blah, blah. And then you attach it on the affidavit. So before the registrar caveats the land, they should ensure that there's some bit of evidence that has been brought to prove. But in terms of lapsing, it's not true that they lapse automatically.
Like if I wake up in the morning when I want to lodge a caveat, where do I start from? Is it a matter of going to the registrar or?
Yeah, it's good to instruct a lawyer to draft for you the caveat papers, because the caveat document is a technical document which should clearly spell out your interest, and then which is accompanied by an affidavit which also is evidence of your interest, and then you do other documentation and pay money because it pays stamp duty to government. But if you cannot instruct a lawyer, usually you can go to the land office. You can get assistance from some of the staff possibly who can provide you with some basic caveat documents which can spell out your interest. And then you must ensure that you know the details of the land you want to caveat, because the caveat is placed on a land title, which some people popularly call white page. Legally we call them the original copies, the copies which remain in the land office. That's where the caveat is placed, and they print it. They print it on the title that there is a caveat by so and so, lodged on this day for this reason. That means that any person wants to carry out a search on that land, when they carry out that search, they'll be able to see that there is a caveat on this land by so and so and for this purpose. Because the caveat, the intention is to notify the whole world. So you go to the land office which takes that particular area where your land is situated, because Ministry of Lands now has different offices which take different areas. So you go to the geographical office which covers the area where the land is situated. You pay the requisite amounts of money to government, stamp duty, registration, and then the caveat will be lodged on the title.
In some instances, land is observed being sold with a pending caveat. But under what circumstances can this happen?
There are two scenarios, because one, when you are lodging the caveat, you're supposed to give an address. Unfortunately, land office is still in what you call a PO box age. They still rely a lot on postal addresses, and they haven't yet grasped or embraced technological things like, for instance, emails or sending notifications on WhatsApp and other social media, although I see them notifying people on Twitter. When a person wants to remove a caveat, the registrar is under duty by law to notify you, the caveator. If I caveat Deborah's land, and Deborah seeks to transfer the land, the registrar is under duty to inform me, the caveator, that the land in which you caveated is going to be transferred. The law only requires them to send a notice through post office. Now the challenge, most people when they are lodging caveats, they use addresses which may not be their own. I may go to a lawyer who is not my ordinary lawyer, it's just a one-off, and he puts, or she puts, a PO box address of his law firm. Or I can go to any other person and he puts a PO box of their own. Now when the land office sends the notice, it goes to a person who doesn't even remember you. This lawyer doesn't remember that in 2016 he caveated a document for, so they may receive the notice. Some people don't even check postal addresses because post office is not like a phone where you receive a notification. Post office, you have to go there physically to see if there's anything. Some people take long to go there. So the only duty of the register is to notify you through the address you sent there, the address you drafted on the document. And in fact, that notice is supposed to be attached when they withdraw it, the notice to you, the caveator. So after the 60 days elapse, the registrar can remove the caveat and the land can be transferred. The other scenario is where the caveat doesn't necessarily bar transfer. For instance, if you are saying that there is a Chivanja holder, I'm claiming an interest as a Chivanja holder, it may not necessarily harm you, or you may not suffer a lot of prejudice if the land is transferred, because whoever person is transferred to will be under duty to respect your rights as a Chivanja holder. So it's only change of ownership, unless you are claiming that you are never given the right to get a first option of purchase. But other than that, under ordinary circumstances, the registrar is under duty to inform you in writing, and if they don't do that, it means that that transfer can be cancelled by court. If you can prove to court that indeed I caveated, but I never got any notice, despite my address being known, then the transfer can be cancelled, because then that means that the caveat would have been lifted irregularly. I think people have moved on from the postal service era. It's still, I know it's still a legal requirement under the Registration of Titles Act. They still talk about PO box. However, I think land office, it doesn't stop it from embracing other, just like they have embraced other forms of notifications. I see them announcing applications for special certificates of title on social media. So I think they should embrace things like phone, like email, such that people have no reason not to know, because the intention is to fight land fraud. One of the biggest ways of land fraud is people lifting caveats irregularly, people seeking transfers irregularly, people seeking special certificates of title irregularly. So it doesn't hurt if you keep on notifying the other people through whatever means. You can maintain your good old post office, but also add on other things like email, like WhatsApp, because these people should be updating with all that information, such that there is no reason for a person not to know that there is something happening.
Lawyer George Musse also explains the options of lodging a caveat on the land as provided for under the law, and proven effective in addressing the issue of land disputes in the country.
It does help, because like I said, the basic intention of the caveat is to notify the whole world. If a person is to conduct a search and they find out that this land which I was going to buy from so and so has a caveat from so and so, I would have been notified. So despite the fact that the person lying to you that there is no caveat, you as the buyer, potential buyer, you're supposed to be put on notice to ascertain who is this one who is claiming a Chivanja. Was she settled? Where is her Chivanja claim? Where exactly is it situated? All those are key things that have to be addressed. So I think it helps a lot. Caveating helps a lot in as far as informing the whole world, and in as far as curtailing any interests that may be irregularly seeking transfers.
With escalating land disputes in the country, Musse also sheds light on what could be the root cause.
The land is one of those resources which doesn't expand, yet the population is expanding. It only rises in value, and if you notice, the higher the value of the land, the more the wrangles, the disputes. That means that there are more wrangles in land around Kampala, the urban areas, than maybe deep in the villages. It has caused people, and also because of the unemployment, it has made people to be very fraudulent. Fraudsters are high, and even fraud is ever-changing face. Secondly, that fraud is helped by corruption, fueled by corruption, and the unequal enforcement of the law. You find that, one, many law enforcement agencies are corrupt or have corrupt officers, and they will not protect the people who are on the right side of the law, but those who are oiling their palms. Then you find also coupled with corruption is the unequal enforcement of the law, that we have so many people who are being evicted, possibly because the person who is evicting has the protection of the state, or state agencies. You find that maybe policemen, yet another rightful person, even when they have a court order, because they don't have the money or the force, they have a problem of enforcing their order. Then we have the very big issue of access to justice. Access to justice in this country is still very challenging. One, law enforcement agencies like police are underfunded, but even when they are funded, they sometimes are slow, sometimes they are corrupt. Then the backlog of cases in court. You find that if you have a very, very urgent application, you're saying that I'm in threat of being evicted from this land, and you lodge it to a court, which for instance, like a high court, which has so many cases. You may even take a week, a month, 2 months without hearing that application, a simple application. Leave alone land cases. Some cases take, especially land ones, take even 5, 6, 7 years in court. So the issue of access to justice, that people cannot easily get a remedy from the law, also fuels the land wrangles, because it means that a person, those who have the might, will be right. That even if you run to court and you spend 1 year in court, or 3 or 5 years, you not get the remedy. Meanwhile, the person who you are fighting against is already occupying the land, they're utilizing it. Sometimes they're even getting money off the land. So it leaves people quite frustrated, and it's one of the leading causes of the wrangles.
Katika mkoa wa Kata Wizi